Okay, good morning, class. Welcome back. This is CRTR 2435, Fall 2017. I'm going to cover the syllabus. That way, everybody knows in case there's a new student, you know exactly what's expected from you. So if you want to print up your syllabus, it's under Start Here tab, the left in Blackboard. And I understand Blackboard may be down, so I'm just going to read this. I'll try and figure it out afterwards. After I'm done dictating, I'll go down to the distance ed office to see what's happening, okay? But this is El Paso Community College Syllabus Part 1, Instructors Course Requirements for Fall of 2017, CRTR 2435, Accelerated Machine Shorthand. This is a distance learning online course. There are no in-person class dates. Faculty information, I'm Lucretia Thomas, CSR, Certified Shorthand Reporter, RPR, Registered Professional Reporter, and CRI, Certified Reporting Instructor. My office is here at the Northwest Campus, room M84. My phone number here at the campus is 915-831-8834. Make sure that you leave a message and I'll get right back to you. My email, which is the preferred course of correspondence, is lucretiat@epcc.edu. And like I said, this is the preferred method of communication is my email. I do check it as often as I can. Of course, in the mornings I'm busy dictating, so I won't have time in the morning, but when I get here first thing in the morning, I do check it. Official announcements and communication regarding your course will be made by email and or Blackboard announcements. So just so you know, okay, they will be made by email and or Blackboard announcements. So make sure that you check your Blackboard announcements. I will always post messages on there. And I do check off the email, so I'm not sure if you all receive the emails or not, but I do check that off. My office hours are going to be using this Zoom. There'll be 1 to 2 Mountain Standard Time and Monday through Thursday. So if you have a question, I'll have this on 1 to 2, and you all can just chime in and ask me, and I should be available. And you can just dial the 915-274-2521. That's also my cell number, but it's also the Zoom meeting ID number. Description of the course. This develops mastery of high-speed dictation, including readback of dictation notes, machine practice, and transcription. To exit this course, students must write on a stenographic machine and pass at a minimum speed of 200 words a minute and 180 words per minute, with 97% accuracy on 2 5-minute time writings each on Q&A material, and pass 2 5-minute time writings each at 180 and 160 words per minute with 97% accuracy on jury charge material, and pass 1 5-minute time writing each at 160 and 180 with 95% on multi-voice material, and pass 2 5-minute time writings at 160 with 97% accuracy on literary material. So that's what you should have at the end of the semester. This is what you want to strive for. Computer technology requirements. You will need a computer, desktop, or laptop that connects to the internet. It is highly recommended that Windows 10 be installed. If you do not own a computer, or if your computer malfunctions during the semester, you will be expected to identify a computer to use. Computers are available at the public library and at the various EPCC campuses. Technology problems are not an excuse for missed or late work. Blackboard mandatory. You will need to contact 915-831-6440 as soon as possible to receive a username and password for access to Blackboard. Please have your student ID number and let them know that you are an online student. Your username and password are required for access to Blackboard. All assignments, labs, and lectures will be accessed through Blackboard. Please be sure to use Google Chrome or Mozilla Firefox as your browsers when using Blackboard for the best internet connection. Really, really important, you all make sure that when you're logging in that you make sure you're going through Google Chrome or Firefox. Some students have in the past not done it that way, and they didn't have access, or it kicked them out, they couldn't hear. So make sure those are your browsers. Make sure you call 831-6440 for your password and username. It's going to be busy because we just started the semester. We're already having some issues. So just keep calling until you get that information. Stenographic machine requirement. You must have your steno machine. I talk about the steno machines. We do have them available. Remember, we have a wave paperless, but the theory students get priority use of those. And I know most of you already have your machines, okay? Software requirements. Case Catalyst is what we use here at the campus. It's also free of charge here in the classroom and in the lab area. So if you're in El Paso, you can use it here. If not, it's okay if you have another software like Eclipse. We do teach the Case Catalyst class, so that's why we use Case. So the lab is going to be open from 9 to 5, Monday through Thursday. Fridays, the lab will be closed here, okay? So if you have any questions, the lab assistants are always on hand. Remember, I teach in the mornings. They're available in the mornings, so they can answer any questions. They can give me a note if it's an emergency. The lab assistants are Michelle Valdez and Kat Santibanez and Monica Sosa. So you have their phone numbers there. And please contact them for any additional information regarding the lab or equipment rentals, okay? All students who are unable to come to the lab, which you don't have to, it's not mandatory, this is an online class, must purchase the Case Catalyst so that you can send us your homework dailies, or if you have another software, okay? So your lab assistant for this class is Michelle Valdez, and you can email her your homework at mvalen22@epcc.edu. And she can be reached at 915-831-8860 or 915-831-8879, okay? The text and materials for this class, it's an optional textbook, and these are for your written knowledge test. So you have under number 1, National Court Reporters Association, how to prepare for the RPR, RMR exams and practice questions for the RPR, RMR exams, and it's sold as a package, 1998 version, available at the EPCC bookstore. And the other books that we highly recommend are the Court Reporter Reference Textbook, Workbook, and Study Guide by Monet Benoit and Emmett J. Donnelly. They're 4 books, and I really hear wonderful things about them. Most students that take the RPR written tests swear by them, so I highly recommend that you purchase those. And then, of course, you have the Uniform Format Manual for Texas Court Reporters, and that is under handouts. So you have your Uniform Format Manual, and what that is just samples of how to produce your transcripts for Texas, okay? So make sure that you have your stenograph machine, that you have software, that you have a dictionary. We use the Merriam-Webster's dictionary just because that's what they use at the state test to grade your state test. It's the 11th edition. It's paperback, very inexpensive. Make sure you have a USB flash drive. Very important, just to download some of your speed buildings. And then you will need to register for your EV360 software, which is free. The college did purchase that for you all. You need your username and password for access. There is, when you log into Blackboard, on the left tab, it's the left tab, and it goes all the way down, and you have EV360. I believe it's the 3rd one. So make sure that you watch it, and that way you know how to get your username and password, okay? It's a demonstration. Course requirements, evaluations. You need to pass 2 5-minute time writings at 160 with 97% on lit material for this class. You need to pass 2 5-minute time writings at 160 and 180 with 97% accuracy on jury charge material. You need to pass 2 5-minute time writings at 180 and 200 at 97% accuracy on Q&A material. And then you need to pass 2 5-minute time writings at 160 and 180, only one of each, with 95% accuracy on multi-voice material, okay? So the grading scale, attendance will be verified by Blackboard, and class must be attended 80% of the time. So if you don't attend 80% of the time, you have 13 or more absences, then you're gonna be given an F or be dropped from the course. So very, very important. A, in order to get an A, you have to pass all your time writings, which is 12 plus 95% of homework, notes, and 95% of dailies turned in. To get a B, 75% of your required time writings, which would be 9, pass, plus 90% of homework notes and 90% of dailies turned in, or 50% of required time writings, which would be 6, plus 95% of homework notes and 95% of dailies turned in. C is 50% of required time writings, which would be 6, plus 85% of homework notes and 85% of dailies turned in, or 25% of required time writings, which would be 3 passed, and then you have to do a little more work, 90% of your homework notes and 90% of dailies turned in. D is if you pass 1, 2, or no required time writings, but you still have to do 80% of the work, which would be for a D, okay? And once you get your dailies and practicum guidelines sheet, the scale is there, and it tells you how many dailies and homework hours you have to have at the end of the semester for the 95, the 90, the 80, and the 85%, okay? So make sure that you see that. in your practicum daily homework sheet, the daily's homework sheet, okay? It tells you, remember it's based on 225 lab hours that you need. 15 times 15 is 225, and then 15 times 3 is 45 for dailies turned in. Note, all required time writings must be passed before the student will be allowed to enroll for CRTR 2331, or unless a grade of I is given. So that's the next class. You don't want to go to the higher speed building class if you're not ready for it, because if you're not passing here, you're not going to pass there. Average grade 90 to 100 is an A, 80 to 89 is a B, 70 to 79 is a C, 60 to 69 is a D, below 60 F. Homework and dailies, notes from 15 practice hours are required per week. Refer to your practicum guidelines sheet under handouts as to how to complete your homework. 5 hours of homework is mandatory in EV360. So you have to turn in at least 5 homework hours in the EV360 every week. Please send your homework and practicum guideline sheet via email to your lab assistant, Michelle Valdez, at mbalin22@epcc.edu, and carbon copy Lucretia Thomas at lucretiat@epcc.edu when using computer-aided software. The homework is due every Monday. So every semester, 15 extra hours of lab hours and 3 dailies will be added to your homework totals at the end of the semester. So I give you that just in case there was a week you couldn't turn anything in. The homework notes for this class for 15 hours of practice average anywhere from 3 to 450 pages. So you all, we're estimating about an hour's worth of time on the machine is about 30 pages. I understand if you're just writing words, it's going to be less pages, but if you're writing dictation, it should be a little bit more, like 30. So we're just estimating, okay? Some of you are not sending in nearly that amount. So please know that we're going to be looking out for that. Should there be any question regarding your homework hours, you should be able to demonstrate to the instructor how you arrived at your weekly total. No more than 20 hours will be accepted at any one time, especially at the end of the semester. The homework and or lab hours to be turned in shall be done according to the practicum guidelines. So you can turn in 20 hours at one time during the semester. If you think you're going to be out of town, that's fine. But remember, you can't turn any more than 20, okay? If you know you're going to be out of town the next week, then you could turn in 20. Remember, I always give you 15 lab hours, 3 dailies per semester. Homework notes that are completed utilizing court reporting software must be emailed to Michelle and carbon copied to me. If you are using Case Catalyst, the best way to send your notes via email is, and I have a little description how to send it to us. Remember, we teach that here, so that's why we use Case Catalyst and we kind of like it. But if you're on Eclipse, you all already know how to use your software, you can send it to us. 3 transcriptions of time writings dailies are required per week. Tests must be typed in their entirety and may be typed at home if not graded. Dailies must be turned in weekly. Remember, your dailies that you do is when you actually go through your notes and read something, you didn't think you passed it, but you're looking at your mistakes, you're entering words into your dictionary. So make sure that when you send in a daily that you're editing it and not sending it to us with all the untranslates, okay? Very, very important. They have to be turned in by September 14, October 12, and November 9, 3 per week. If you're not turning in your amounts, you're gonna get a little notice from us saying how many we have for you. So very important that you keep up with your dailies, 3 per week. This is to ensure dailies are being typed up during the semester. Any dailies not turned in during this time period will not be allowed to be turned in at the end of the semester. Dailies should be turned in utilizing computer-aided transcription, Case Catalyst, or any other CAT software. Makeup exams, a student has 1 week to access Blackboard. Make sure that you access everything within that 1 week period, okay? So let's say today you have jury charge, so you'll have 1 week from today to access it, but I would keep up with it daily. Extra credit assignments may be done as per the instructor. A student may receive no more than 20 extra credit hours per semester. So you will be given options to complete some extra credit, okay? Let me know if you're interested. Blackboard recordings, please call 915-831-6440 to obtain your username and password for access to Blackboard. Tell them you are an online student. Remember, I can't stress how important it is. Make sure that you call and get it if you're a first-time student here. Attendance is going to be verified through Blackboard, and all activity is monitored in there. Of course, if you log in live with me, I will mark it down, so that counts as well, okay? Anytime you log in, I will mark it down. If you don't access the class at least 80% of the time, you will be dropped or given an F. And you must access your Blackboard recordings on a daily basis. Students will not have access to the Blackboard recordings after 1 week has elapsed. This will be strictly enforced. Any test typed after the 1 week period will not count as a pass. Very important that you all know that. If tests are typed at home and it's a pass, please email your notes to your lab assistant the next class session or the test will not count. Instructors' policies, remember to call 831-6440 for your username and password. Log into Blackboard for attendance if you're not logging in with me. Live class will be at this time, 10 to 10:50 Mountain Standard Time if you want to log in and read back with us. Remember, it's not mandatory, it's optional, but I highly recommend it. I give you the instructions how to log in, and then withdraw from class under B. It is your responsibility to withdraw from the class in accordance with community colleges' policies, procedures, and timelines. The instructor may drop any student who does not access Blackboard. The last day to draw with a W is Thursday, November 9th. I will be emailing you if you need to drop and get your consent, and I can drop you or you can drop yourself. A grade of I is an incomplete, and it will be given solely at the instructor's discretion. Such factors as attendance, number of tests needed, homework completed, etc. will be given consideration. You are allowed 4 months to complete the time writing. Should you choose not to re-enroll for the same course the following semester, you will have to make arrangements with the instructor to take the time writing tests. Okay? Student conduct, cheating will not be tolerated. Any student in violation of the Code of Student Conduct will be reported to the Vice President of Student Services. Persons who are caught could be subject to community college sanctions as well as being given an F on the assignment. Students' notes may randomly be audited on past tests. This is to ensure the integrity of online testing. So at any point I could audit anybody's notes just to see what you have compared to the typed up portion, okay? E, student responsibility. Misunderstanding or confusion should be communicated to the instructor. Students have the primary responsibility for asking for help in completing the course objectives and in seeking assistance when needed. Students are encouraged to keep their own records of dailies and lab hours turned in. And so that's under handouts. Start here, information for the class. There's a tab for handouts, and it's called the dailies and lab hours sheet. That's where you keep track of how many hours you turn in a week. There's little slashes there for you that you can keep track of, okay, by the number of hours. Lab area conduct, I don't foresee any of you coming into the lab area. Remember, it's just optional, not mandatory if you're in El Paso. But under G, to carry over time writings, which are past tests, from one semester to the next, the student must, so we carry over your test, but in order to do that, whenever you pass something a semester, you have to come back the next semester and you have to at least get a D in the class. So you have to at least do 80% of the work and dailies to get a D, okay? The calendar for this class, Mondays, we're gonna have jury charge speed building at 160 and 180 with tests. Tuesdays are Q&A speed building at 180 and 200 and tests. Wednesday, literary speed building at 160 and tests, 160 lits. Thursdays, we have multiple voice speed building at 160 and 180 and tests. And then the last day to withdraw with the W is Thursday, November 9. Finals will be December 4 and 5. Roll will be taken through Blackboard if you're not logging in with me, and you're going to get 2 examinations of each speed test, and they will be given, and I'll send you a short email to let you know, or via an announcement through Blackboard, how the tests will be conducted, okay? Remember, this calendar is subject to change. Under 7, certification exams, written knowledge tests. Remember, we give all this information for your state test. You have the JBCC and the TCRA that you need to contact regarding if you want to take your written test or if you qualify for your machine test. Remember, the written test is good for life. Once you pass it, it's there for life, okay? They always keep track of it. So now's a good time to think about taking your written test for Texas, the CSR. The next exam is not posted yet for Texas for the machine portion and the written, so we're still waiting for that, okay? But read everything on the exam TCRA is in charge of, and JBCC. Withdrawal policy, beginning fall 2007, all freshmen enrolled for the first time at any Texas public college or university will be limited to 6 course drops during their entire academic career. Drops include those initiated by the student or by faculty and those incurred at other Texas institutions. This policy does not apply to courses dropped before Census Day or to complete withdrawals from the college. When you register, see your advisor, choose your courses carefully. Before you drop a course, see your advisor, discuss options with your professor, use campus resources such as tutoring labs, computer labs, etc. So what this means is you're allowed drops in Texas, only Texas, not any other state, beginning fall 2007. Any W's that you got, I think after the seventh W will count as an F, okay? The 6th W is a W, but the 7th will count as an F. So in court reporting, I know it's really difficult, and there's always a lot of times that you need to drop because you didn't meet all the requirements, so just keep that in mind. I'm now going to your official syllabus, that's part 2 syllabus, and I just wanted to read on the second page under Roman numeral 5, the Disability Statement, Americans with Disability Acts. You have, make sure you're with me, EPCC offers a variety of services to persons with documented sensory, mental, physical, or temporary disabling conditions to promote success in classes. If you have a disability and believe you may need services, you are encouraged to contact the Center for Students with Disabilities to discuss your needs with a counselor. All discussions and documentation are kept confidential. And the offices are located here at the Northwest Campus, room M54, and the number is 831-8815. So we have several campuses. I've listed all their numbers and their campuses. If you feel for whatever reason that you need to contact them, everything is kept confidential, okay? So I will now go on to some speed building, okay? So if you all want to get your machines ready, if you have any questions, please don't hesitate to send me an email. Okay? Today's jury charge. And so I will start with a little bit of the speed building since I have time, you all. Maybe I'll just do the fastest speed, okay? So you have jury charge speed building. I think I can read at 190, and I'll read it 4, 5, I'll do 180, 190. Okay? Let me give you some words that come out on your speed building. You have believability. You have non-existence, contradictory. You have constitution, escape, Jim Marcus, Illinois. You have applicable, Bart Marcus, expectancy, exclusive, decedent. And so let me write decedent for you on the machine. I think it's D-E and then seent, S-long-E-N-T. Yes, decedent, Illinois. I-L, ill, and then noi. Okay, Illinois. This is going to be at 180, you all. Ladies and gentlemen of the jury, now that you have heard all of the evidence and the arguments of counsel, it becomes my duty to give you the instructions of the court concerning the law applicable to this case. It is your duty as jurors to follow the law as I shall state it to you, and to apply that law to the facts as you find them from the evidence in the case. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me. As stated earlier, it is your duty to determine the facts, and in so doing, you must consider only the evidence I have admitted in the case. The term evidence includes the sworn testimony of the witnesses and the exhibits admitted in the record. Remember that any statements, objections, or arguments made by the lawyers are not evidence in the case. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might, however, escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. So while you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and the evidence in the case. Now, I have said that you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. You are the sole judges of the credibility or believability of each witness and the weight to be given to his testimony. In weighing the testimony of a witness, you should consider his relationship to the plaintiff or to the defendant, his interest, if any, in the outcome of the case, his manner of testifying, his opportunity to observe or acquire knowledge concerning the facts about which he testified, his candor, fairness, and intelligence, and the extent to which he has been supported or contradicted by other credible evidence. You may, in short, accept or reject the testimony of any witness in whole or in part. Also, the weight of the evidence is not necessarily determined by the number of witnesses testifying as to the existence or non-existence of any specific fact. You may find that the testimony of a smaller number of witnesses as to any fact is more credible than the testimony of a larger number of witnesses to the contrary. A witness may be discredited or impeached by contradictory evidence by showing that he testified falsely concerning a material matter or by evidence that at some other time the witness has said, or remember, number of is NUFRM. Let me see. Number of, NUFRM, okay, number of. You have determined, DERM, come back, D, determined. You have establish is blish, BLIRB. Interpretation, SBWERPGS, interpretation, one stroke. And this is going to be at 190 for 3 minutes. Ladies and gentlemen of the jury, now that you have heard all of the evidence and the arguments of counsel, it becomes my duty to give you the instructions of the court concerning the law applicable to this case. It is your duty as jurors to follow the law as I shall state it to you and to apply that law to the facts as you find them from the evidence in the case. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me. As stated earlier, it is your duty to determine the facts, and in so doing, you must consider only the evidence I have admitted in the case. The term evidence includes the sworn testimony of the witnesses and the exhibits admitted in the record. Remember that any statements, objections, or arguments made by the lawyers are not evidence in the case. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. So while you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and evidence in the case. Now, I have said that you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. You are the sole judges of the credibility or believability of each witness and the weight to be given to his testimony. In weighing the testimony of a witness, you should consider his relationship to the plaintiff or to the defendant, his interest, if any, in the outcome of the case, his manner of testifying, his opportunity to observe or acquire knowledge concerning the facts about which he testified, his candor, fairness, and intelligence, and the extent to which he has been supported or contradicted by other credible evidence. You may, in short, accept or reject the testimony of any witness in whole or in part. Also, the weight of the evidence is not necessarily determined by the number of witnesses testifying as to the existence or non-existence of any specific fact. You may find that the testimony of a smaller number of witnesses as to any fact is more credible than the testimony of a larger number of witnesses to the contrary. A witness may be discredited or impeached by contradictory evidence by showing that he testified falsely concerning a material matter, or by evidence that at some other time the witness has said or done something, or has failed to say or do something which is inconsistent with the witness's present testimony. If you believe that any witness has been so impeached, then it is your exclusive province to give the testimony. And so remember, we're a little short on speed building today because of covering the syllabus, but tomorrow should be a normal day with Q&A, okay? Unless you have any questions for me, don't hesitate to ask me. So I'm going to start with your 180 Q&A test. So make sure that you find your spots, that you clear your memory. And so on your 180 tests, proper names you have John Burt, Dothan, United States, Government, Schedule 2, Exhibit 1. Okay, and this is going to be your 180 jury charge test number 1 for 5 minutes. Starts in the middle. We have reached the point in this proceeding where it is appropriate to instruct you regarding the law. I am not going to talk loudly. I am almost talked out today, so be patient. Give me your attention. I will be discussing with you principles that I have discussed before when you sat on juries. It is necessary in each case that the judge talk to the jury and advise them as to certain propositions of law. Many of the principles apply in each case, namely the burden of proof and the presumption of innocence. You will see that in each case there are some different principles. I do not set out these principles of law for you for the purpose of emphasizing them. I do it because it is my duty to advise you as to the entire law that pertains to a given case. It is likewise appropriate that you understand your function in this lawsuit. You are the fact finders. It is your job to judge and evaluate the evidence, and from the evidence you heard during the trial, determine what the true facts are. And then you take these legal principles, apply them to the facts, and bring in a fair verdict. The government is entitled to a fair verdict in this case. The defendant, Burt, is entitled to a fair verdict. You can only discharge your duty by giving them a fair verdict when you return a verdict based on the law without regard to other matters. To decide a lawsuit is not an easy task when you are called upon to put aside your opinions and your bias or prejudice. You cannot discharge your duty, that is, decide this lawsuit, whether you are a juror or a judge, if you do not base your decision on the facts and on the law that is controlling without regard to anything else. You are expected and your oath requires that you do that in this case. The case reaches the court by an indictment. Indictments are not evidence. Indictments are not proof of guilt. Indictments are merely a means we use to administer justice in this country, to advise the defendant and counsel as to the charge in this case. You may have the indictment for any purpose it serves in guiding you in your deliberations, but I caution you that it is not proof. It is not evidence. The indictment in this case charges that John Burt, on or about June 6 of this year, here at Dothan, unlawfully disposed of 50 grams of cocaine in a manner which violates one of the criminal laws of the United States. John Burt, as with all the defendants in our system, comes to the trial in this case presumed to be innocent of the charge here stated. This presumption of innocence stays with him. He is clothed with the presumption of innocence throughout the trial of the case. He will retain this status while you deliberate the case until you arrive at a point in the course of your deliberations, if you do reach this point, of finding that the government has sustained its burden of proof. Upon reaching this point, if you do reach it, then the presumption of innocence is removed from the case. It has served its purpose. Its purpose is to place the burden of proving the guilt on the government, as opposed to its being the defendant's burden to prove innocence. It is the burden of the government to prove John Burt guilty as charged in the indictment beyond a reasonable doubt. A reasonable doubt is a doubt for which you jurors may find a reason growing out of the evidence in the case, or because the burden is upon the government growing out of the lack of evidence in the case. There are distinct elements in this charge. The government must prove each of the elements and do so beyond a reasonable doubt. It must prove first that John Burt acted knowingly and unlawfully, that is, that his conduct to the extent that it is material in this case was deliberate and in violation of the law. I charge you, members of the jury, that it violates the law to sell cocaine. That sale of cocaine is a violation of the law. Cocaine is, I charge you, as a matter of law, a Schedule II controlled substance. I further charge you that cocaine is contained in Exhibit 1 as has been stipulated by the parties in this case. The government must prove that John Burt distributed the cocaine, that he did it knowingly, and that it amounted to 50 grams of cocaine. There is some evidence in this case that Burt fled when the officers went to arrest him. Evidence of flight in an attempted arrest for a crime is not sufficient in and of itself under the law to establish guilt, but is a fact which, if proven, may be considered by the jury in light of all the other proven facts which have been placed in evidence when deciding the question of and then we have your second 180 jury charge. Proper names you have Will Trust, Spencer Anderson, First National Bank of Arizona, Mrs. Esther Bentley, Myrtle Anderson. And this is going to be 180 jury charge number 2 for 5 minutes. Starts in the middle. I will now tell you the rules you must follow to decide this case. I will instruct you on the law. It is your duty to follow the law. It is also your duty to determine the facts. You must determine the facts only from the evidence produced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion you may feel I have about the facts. You are the sole judges of the facts. You must take account of all my instructions on the law. You are not to pick out one instruction or part of one and disregard the others. However, after you have determined the facts, you may find that some instructions do not apply. You must then consider the instructions that do apply together with the facts as you have determined them. Decide the case by applying the law and these instructions to the facts. You must find the facts from the evidence. The evidence which you are to consider consists of testimony of witnesses and exhibits. At times, I decided whether testimony and exhibits should be admitted. When an objection to a lawyer's question was sustained, you are to disregard the question, and you are not to guess what the answer to the question might have been. When testimony was ordered stricken from the court record, you are not to consider that testimony as evidence. Do not concern yourself with the reasons for these decisions. Admission of evidence in court is governed by rules of law. In the opening statements and closing arguments, the lawyers have talked to you about the law and the evidence. What the lawyer said is not evidence, but it may help you to understand the law and evidence. The lawyers are permitted to stipulate that certain facts exist. This means that both sides agree those facts do exist. You are the sole judges of the credibility of the witnesses and of the weight to be given to the testimony of each of them. In determining the weight to be given to the testimony of any of the witnesses, you may take into account their ability and opportunity to observe, their memory, their manner while testifying, any motive, interest, bias, or prejudice they may have, and the credibility of that testimony considered in the light of all of the evidence in the case. A witness willfully false in one material part of his or her testimony is to be distrusted in others. The jury may reject the whole of the testimony of a witness who has willfully sworn falsely as to a material point. If you are convinced that a witness has stated what was untrue as to a material point, not as a result of mistake or inadvertence, but willfully and with design to deceive, then you may treat all of his or her testimony with distrust and suspicion and reject all, unless you shall be convinced that he or she has in other particulars testified to the truth. The rules of evidence ordinarily do not permit the opinion of a witness to be received in evidence. An exception to this rule exists in the case of expert or lay witnesses who have special knowledge or experience. Any person who by education, study, and/or experience has become particularly knowledgeable or an expert in any art, science, or profession may give his opinion as to any such matter in which they are versed and which is material to the case. You should consider such opinion and should weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct evidence and circumstantial evidence. There is no distinction between direct evidence and circumstantial evidence as a means of proof. Neither is entitled to any greater weight than the other. Direct evidence means evidence that directly proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. As you are aware by now, this proceeding is basically a contest of the will of August 29, 1985, with additional consideration given to the validity of the trust of the same date, which trust is referred to in and involved in the disposition of property by Spencer Anderson. First National Bank of Arizona is the personal representative named in the alleged will and the trustee of the trust of the decedent, Spencer Anderson. In this proceeding, it is one of the defendants, Mrs. Esther Bentley, who is the beneficiary of both the will and trust, is the other. Myrtle Anderson, who is the surviving spouse of the decedent, is the plaintiff. Before the commencement of this contest, the will of August 29, and then we'll get ready for your 160s. 160, number 1, you have criminal action 93-CR-5496, People versus Alan Jean Adams, Marie Schmidt. You have Mr. Alstrom. Mr. Alstrom. Okay, and this is going to be $160, number 1, for 5 minutes jury charge, okay? Five minutes, you all. Good morning, ladies and gentlemen. This is Criminal Action 93-CR-5496, People versus Alan Jean Adams. Have the record show in the third day of trial that the defendant is present in court represented by counsel and the jury is in the box. Ladies and gentlemen, I have a few remarks I want to make before we commence the trial this morning. Some of it is in answer to a question or two that jurors asked the bailiff. We do not permit note-taking and ask that you not take notes during this trial. The trial is not going to be all that long. I know it's done in some trials that go 6 or 7 months where you can't remember back what happened 5 or 6 months ago. But there is a disadvantage and possibly prejudice in taking notes, where one juror will take more notes than the other, and he may not take the notes down accurately, and it may have an undue influence on another juror. So we have agreed there will be no note-taking. The reading back of testimony. Again, we do not permit the reading back of testimony after the trial is over. and you're in the jury room for deliberations. Sometimes jurors have asked portions of certain testimony be read back, and we do not permit that. Because again, it places or could place undue emphasis on certain testimony. And we certainly can't read back the testimony of all the witnesses in the entire trial to you. Now, if at any time you cannot hear the question or you didn't hear the answer, if you'll raise your hand, I'll have it read back to you during the trial. But otherwise, we will not read back any testimony. The question was asked whether or not you can ask questions during the trial. We do not want you to ask questions. It tends to disrupt the trial. And the trial is conducted by the attorneys who are trained in the law, and they know the questions they can ask and what they're supposed to ask, and the judge will make the rulings, as I will explain to you in a few moments. We prefer you just listen very carefully to the testimony. I mentioned also to the alternates that you be sure you listen very carefully because you may be sitting in there in the end. We have one juror who isn't feeling well. And if you do need to go to the restroom, or for that matter, any of the other jurors, anytime you need to go to the restroom, like in school, I'll let you go. I might say in that regard that we had 2 days of questioning. And from time to time, as a little relief, I guess, from the repetition of questioning, there was some funny things said and some laughter. But this is a serious business, and here on out, we want you to consider it that way. We have another additional reporter here that I would like to introduce to you, Marie Schmidt, who will be sharing the duties from time to time with Mr. Ahlstrom. Now, for those of you who have not participated in a trial, I want to explain to you at this time the order of the trial. First, the district attorney has a right to make what we call an opening statement. The opening statement is not evidence. It's what he expects his evidence to be, what he expects his witnesses to say, and what he expects to prove in this case. It's kind of a summary or synopsis of his case. After he's finished doing that, defense counsel has a right to make a similar opening statement, or he may want to reserve his opening statement to a later time, which is his privilege. The district attorney then commences his case by calling witnesses. The witness comes to the stand and is sworn, and the district attorney examines him. This is what we call direct examination. Then it goes over to the defense counsel for what we call cross-examination, back over to the prosecution for redirect examination if he cares to exercise it, back over to defense counsel for cross-examination if he cares to exercise it. This goes on through each witness throughout the trial. Now, from time to time, there will be objections, and we will talk about this on voir dire. It's the duty of an attorney to make an objection if he feels the question is improper, or the answer improper, or the evidence that is offered is improper under the law. This is a ruling that the court has to make, and I don't want you to think for 1 minute that, okay, and then we go on to our second 60. So here we go on your second. You have Ms. Shapiro, instruction number 10, and Ms. Shapiro. This is going to be 160, number 2, jury charge for 5 minutes, you all. Ladies and gentlemen, once again, circumstantial evidence is the proof of facts from which other facts may reasonably be inferred. The other is direct evidence, such as the testimony of an eyewitness, one who saw the act to which he or she testified. Instruction number 10 refers to a culpable mental state. When we talk about culpable mental state, in short, what we are saying is that the person who did this had to know what he was doing, that it wasn't a mistake, that it wasn't an accident, Now, the culpable mental state required for first-degree murder is that it was done intentionally. So the instruction that follows the instructions on first-degree murder talks about culpable mental state. The culpable mental state for first-degree murder is that it was committed intentionally, that there was intent to commit murder, and so we say that a person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense of murder. It is immaterial whether the result does or does not actually occur. Ladies and gentlemen, the time is approaching when we will have the bailiff escort you to the jury room to begin your deliberations. The bailiff will also bring all exhibits that have been entered into evidence as well as copies of instructions you have been given. When you reach the seclusion of the jury room, your first task will be to select from your members a foreperson to preside over your deliberations and sign whatever verdict you reach. You will deliberate in earnest and give us a verdict for everyone concerned in this case. Your verdict must represent the considered judgment of each juror. It is necessary that each juror agree to the verdict reached. In short, any verdict must be unanimous. There are written instructions on each verdict form that you are given. When you reach your verdict, the foreperson will follow the instructions for the form applicable to your verdict and then sign the form. No other markings are to be made on the verdict forms or the instructions. You will then notify the bailiff that you have reached a verdict. You will remain together in the jury room until called into the courtroom. Actually, ladies and gentlemen, you will have only one verdict form and it will be attached to the court's copy of the instructions. As I told you at the beginning of the trial, one of you is an alternate juror. And Ms. Shapiro, that is you. And you are going to be excused at this time. I don't know, maybe that seems like a dirty trick to play on you. Make you sit through all this and then not let you deliberate. But you played a very important role because, as I explained at the beginning of the trial, if for any reason some juror would have become ill or not have been able to finish the trial, then you could have stepped into their place and it would have prevented us from having to start the trial all over again. Let me instruct you at this time that you may discuss the case with whomever you wish. I would suggest you may want to wait until the jury reaches their verdict. If anybody insists on discussing the case more than you want to discuss the case, or somehow becomes critical of you, or pressures you in any way, please report it to me. Thank you, Ms. Shapiro. You are excused at this time. Ladies and gentlemen, if you will follow the bailiff into the jury room, she will discuss lunch with you. It's 12:30 p.m. and we will recess pending the return of the verdict by the jury. Ladies and gentlemen of the jury, it is 9 o'clock this morning. You have not yet reached a verdict, so just go on into the jury room, but please wait until everybody gets there before you start deliberating again. One more time, let me instruct you not to discuss this case among yourselves or with anyone else, and if for any reason you hear any news accounts of the case, please disregard them. As I said, the press did show some interest at the beginning of the trial. I have not seen them around lately. Maybe they got bored with us. In any event, we will recess pending the return of the verdict by the jury. Ladies and gentlemen of the jury, it is now 5:30 p.m. and this case is completed. Let me read you one more instruction. You have now completed your duties as jurors in this case and are discharged with the thanks of the court. Thank you for the time you have. Okay, and capitalize court when you can replace judge in the sentence. Okay, you all? That's it. Welcome back. We'll have more speed building tomorrow. Let me know if you have any questions, okay? Have a great day and welcome back. Let's give it your all, okay?